during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week and deal with the issue. My learned colleague, Mr. Ongoya, can take it from here. No, my lord, I have finished. My learned colleague, Mr. Ongoya, to say something.
My lords, my lady, I just have a few points to highlight. There's a question by Dr. Kamoto on misjoinder of his clients. Let me just make a simple point that with the limited question whether the DCJ can constitute this bench under Article 165 Clause 4 of the Constitution, the question of joinder, misjoinder, non-joinder is absolutely irrelevant. There's no bearing on that question completely, and that would be a straightforward answer to that issue. Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyamodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court says. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases. The Umtata case, the Kemri case, and the Leila Conchela case. The Umtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I have only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Agenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no timestamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said, Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this would find themselves in the file through affidavit. This evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We would therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters that is where a question of principle arises, and of all the three organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
My Lord, I'm a full-time lawyer, full-time. I appear in the Magistrate Court, High Court, Court of Appeal, and I appear before what we are arguing here is a matter of law. It has absolutely nothing to do against any of you, either individually or collectively. We are arguing this matter as a matter of principle, saying that things have not been done properly. And it's because, my Lord, and my lady, Kenya is an interesting country. There is a book here which I read from time to time, the Constitution of Kenya Community. The Constitution of Kenya Community. There is a section in this book which is very interesting. It says, and so I came relate to this matter, I would have been able to go through and flag a particular sentence. There's a sentence which says this. Kenya is one of the most corrupt countries in the world. In this book, it's written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on national security. Suspicions are cast on the Senate. And my Lord, we appear before the Lord. When suspicions are cast on this court, we stand up and protest loudly. All that you are arguing very respectfully. My Lord and my Lady, let this matter, well, what my friend has said, let this matter go back. If he endorses you, he recommends you, we have no problem. You have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perception that there is corruption going on in National Assembly, in the Senate, and in the judiciary. Let the matter go back. Now, it was said to you that there are certain individuals who are above the law. That's not correct. When you are appearing before the lordships and my lady, we should show that actually we are really learned in the law. All of us, as the land friend, is a keeper point that quite properly. All of us are under the law. The judges are taken to court. The Chief Justice can be taken to court. The Speaker can be taken to court. The President can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the Director of Criminal Investigations is at liberty to investigate on the President of the United States. It's my humble submission that we shall be advancing the same argument. That in this case of Gachagua, no Director of Criminal Investigation was called or summoned to give evidence. Am I wrong, Mr. Mutembei? I'm right. Thank you. I'm glad I'm still right. No director of criminal investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectfully. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sir James Woods never got on very well at all. They quarreled from time to time, but they couldn't work together. I happen to know Chief Justice Trevedian and Justice Martin were not friends. They used to throw some things against one another, but they continue to work. Some of us who have been married and so on, we know that actually at times a wife can quarrel, and at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we're saying. This nation has to survive the crisis. We cannot destroy the nation by saying because of president and deputy president quarrel. That is very, very naive way of looking at life. Thank you very much. And that I'll be advancing the arguments of alternative dispute resolution. I put them on notice. Okay, if you're advancing the notice, the alternative notice dispute resolution. You can get president like Mutembei, we can get our archbishops, we can get our retired Supreme Court judges to sort them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two of them cannot get on well. That is a very, with respect, that's a very childish way of approaching this. Thank you. I have a book here that I can donate to you. And a presidency.
I have it also.
Oh, thank you. Yes. May I say I'm very happy that you are those you read so widely.
I always do.
Maybe I can be allowed to respond to one issue.
So Senior Counsel Paul Muti, are you responding?
No, in the interest of time, I will go along with the submission.
Then we can give you 1 minute.
Yeah. Just 1 minute.
Your name again?
Yes, Kimoto Teresio and Jiro Makazi, Montes Kimoto and Company Advocates, Kerugoya. Yes, I wish to respond just briefly on one issue. That is the issue of service. There was an issue raised that the notice was not necessary. And we insist that because today was inter-parties hearing, then the notice was necessary. We also wish to say that one can do a good thing, but at the wrong time. And the reason why we are saying this is that the Chief Justice, though we are being told, you have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Chief Richard Mwongo at Kerugoya, and there's nothing else. So the Kerugoya matters, they have nothing else there. And we have been told this internal memo was filed as petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at a wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that we infringe other people's rights. So we are saying, let us be heard fairly, and we be given enough time to respond to all the motions that are before court, and also the petitions or the responses filed, so that we cannot be prejudiced. That's all.
Your Lordship, with your very kind permission, my name is Akimpa. I just have one issue to respond, and that is by Professor Mutembei on, Your Lordship, Professor was so precise as to the time when the file was transferred from Kirigoya, that is at 3:45 p.m. Your Lordship, I have also taken the liberty to look at the order that was issued in that matter. And it was, the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, or rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E014, it was transferred to Her Ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition which was filed in Karagoya, the lawyers who did that yourselves
Yes, Your Lordship.
should answer that question.
Your Lordship, and that's the
Yes, that is your question to answer. You cannot post it to us.
Your Lordship, it's in the context of the matter in which.
Yeah, you must balance all issues. You don't, when an issue favors you, you want to raise it up. When it doesn't favor you, you want to put it down.
I'm well guided, Your
The
Lordship.
each orders which came from Karagoya were your orders. Thank you very much.
Thank you, Your Lordship.
Thank you very much. Before we make final orders, please keep quiet. Before we make final orders, we as a bench, we want to thank all counsel for the mature way in which we have conducted today's proceedings and the legal arguments which we have put. They are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Leadership, perhaps before you turn off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that were not before you coming up for a mention tomorrow, because there is an application for your refusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and I'm still beseeching the court that there are other petitions that were filed on this same matter, and which applications were made, including temporary injunctions, but which were not given, and which it would be good use of judicial time if the petitions and the applications therein were heard together with the applications that are in this matter. And I would like to point out that if this bench, which is a high court, proceeded to hear the issues that surrounding the conservatory orders in this application, the 3 applications that are before this bench, absent the participation of the applicants in all those other files which have already been filed, we would suffer prejudice, because we would be arguing applications after the court has already sat, and we would be reinviting the court to argue the very same thing. So I would wish, as the court retires, to consider that. Thank you.
Okay, maybe before the Honorable addresses, I just want to make this clear again. We will not deal with any file in which we have not been empaneled. If you filed a petition and it is yet to be empaneled, it is upon you as council to follow it up with the deputy registrar of the court. First of all, we'll have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, it comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were paneled with, which we were paneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we're dealing with matters where we have been formally moved. Thank you.
Yes. Madam, very well kinded, and we do thank you for holding the flag of justice so far.
Your Lordship and my lady, on behalf of the restaurant, I want to thank you for according us audience this afternoon to this evening. I want to thank you for your patience. And as the teacher ahead of the bar, I want to encourage my learned friends that we must continue being respectful, professional, and holding the dignity of these courts very highly, and protecting the dignity of the courts and the dignity of our country. Thank you so much, and have a blessed evening.
Thank you.
Madam Mayor, I'm sorry, I like talking. Madam Mayor says that I am most grateful to the remarks of the Honorable Lady Attorney General. And if I may say so, with respect, in the most recent times, she has shown that the courts must be respected by herself personally appearing in court. There are some previous attorney general whose name I would not like to mention, and who are full-time office workers.
We reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank you.
Let's see how it goes.